City versus National Association of Government Employees.
Mr. Sheketoff?
If it please the Court, Robert Sheketoff for the appellant, Mr. Arcidi. I don't know exactly why this Court took further appellate review. This case, as it presently stands, is a dispute about a $200,000 initial payment to Mr. Arcidi. The Superior Court granted summary judgment on the counterclaim of Nage. The appeals court took the position that perhaps the counterclaim was not made out in summary judgment, but enough was made out on the record that rescission was appropriate because the parties were not on equal footing. We asked for further appellate review on the theory that that was an unpled position in the Superior Court, and in any event, on this record, the parties were on equal footing, that the appeals court had left out of its decision the fact that the contract had been drafted by union counsel and that other members of the board had been involved, the union board had been involved in agreeing to the contract. It is our position that the appeals court was correct in concluding that aiding and abetting a breach of fiduciary duty was not made out in summary judgment because of the knowledge requirement, which they simply had no evidence of, except for this theory that this contract was unlawful, violated General Laws Chapter 3, Section 42, and therefore, I suppose, knowledge of this unlawfulness can be imputed to all the parties. I think
Is there, what authority is there that unlawful intent is required?
Just the case law in the Commonwealth already.
Well, I take it let's say your client knew the contract was unlawful.
Yes.
Is that established in the record that he knew the contract was unlawful?
No, absolutely not.
But it's conceded that the contract is unlawful.
No, I'm not so sure the contract is unlawful. The appeals court doesn't even take the position the contract is unlawful. They take the position it probably is unlawful.
Well, I take it, Mr. Sheketoff, with respect to that, your position is this is somebody who was, among other things, an expert in seeing through the whole permitting process of building this project. One way to look at the contract, the consulting agreement, is to say, put it this way, if it is correct that that's what they are agreeing to, namely that the project has to be actually built, so this is a party saying, I don't want to pay you $250,000 unless I see the end result, correct?
Yes, that's what the contract actually says.
So here it says, is approved and built. I take it part of your argument is that the approval process is part of being, you have to get permits. So you have to go forward and get the darn thing approved before it is built, correct?
Yes.
So that it is at very minimum arguable that this is not a flat-out violation of the statute.
Right. It seems to me problematic whether it's a violation of the statute or not. The statute is intended to make illegal a contingency so that if the contract had said, if you get this approved by the Mass Turnpike Authority, we will pay you, that I think is a clear violation of the statute. But that's not what the contract says. The contract says if you get it approved and built, you can't get it built.
You couldn't get it built without getting it approved.
Correct.
But it
And that seems to me, there is a contingency here, getting it approved. The fact that there are additional contingencies prior to payment seems to me doesn't change the operative fact that one of the contingencies was an unlawful one, namely the approval.
Well, except that...
It gave your client all the incentive to do all the wrong things that the statute is aimed to prevent.
Yes, but let's say it just said built, if the contract said...
Even before you get to that,
Okay.
it's the providing said development is approved and built. It doesn't say, I'm giving you, it's in the passive, I'm giving you consideration for getting the approval. It doesn't say that at all. It simply says, this thing has to be approved and built. It doesn't say, I'm giving you consideration for either getting it approved or getting it built.
Right.
Correct?
Yeah.
It's in the
I agree. My position is not that some court someday couldn't say this contract is illegal. I'm just saying it's very unclear whether it's illegal or not. If the word approval was not in the contract at all and just said built, what you suggested, Justice Osmond, would be true, too. You'd still need to get it approved. And I'm not sure that it would be illegal to hire a consultant to get some project built just because a portion of that process includes approval. He could lose or she could lose her contingency at the approval stage or at some further stage down the road.
Correct. But wasn't this is not a situation where, you were hiring a contractor. Your client was being hired specifically because of his potential to have access and input and contacts with people that would help NAGE in the approval process.
At least in part, that's correct.
At least in part. And didn't he get a very substantial payment after the approval came through and before the building was built?
After the approval, but after all this permitting had been done, so it was absolutely clear that the building would in fact get built.
Aha, but he got the $200,000 that people are now fighting over, he got before the building was built.
Right, but when it was absolutely clear the building would be built.
I take it that your argument is that to the extent that you may have a court say, as at least one court did say, that this is a violation of the statute. If you go to whether or not the money has to be returned, the question is, was there the requisite intent that this was?
Right. I suggest this is a good case for not inferring knowledge because it's not so clear that the statute was violated. And unless you can impute knowledge by that fact, that there's an argument that the statute was violated, I don't think there's any evidence in the record that there was knowledge. You need knowledge, based on the case law, to win this tort of aiding and abetting a breach of fiduciary duty.
Knowledge of what? Knowledge that the contract was illegal.
Yes.
Is that what we're talking about?
Knowledge that you're breaching a fiduciary duty, and the only theory of breach is that the theory of breach is that it's an illegal contract. Therefore, you've breached your fiduciary duty.
But all your client has to know is that it's an illegal contract.
I believe if my client knew that it was an illegal contract, he would know that NAGE was breaching, or the president of NAGE was breaching his fiduciary duty.
And I take it, at least for summary judgment purposes, you look to the fact that, for example, an attorney drafted the contract.
Correct. An attorney for the union drafted the contract. Perhaps that's why I put it in language of and built, not just
But the essence of the illegality is that it's a contingent fee. He wasn't being paid on an hourly basis. He was being paid on the contingency that the approval would be obtained. And that's the rub.
Well, he was being paid on the contingency, according to the contract, that it would be approved and built.
But it doesn't. The built is totally irrelevant. So long as one of the contingencies is government approval, that's the illegality.
Well, I think it's arguably the illegality. I just don't think it's clearly and unequivocally an illegality, so that one would be imputing knowledge that there's an illegality here.
At least not as a matter of summary judgment.
At least not as a matter of summary judgment. It's conceivable to me that if the right questions had been asked at the deposition, he might have said, I was aware of this statute, we thought we were getting around it for this reason or that reason. I don't know. It's not in the record. This is a summary judgment where even the appeals court, where we lost, says there's not enough evidence of knowledge. We were going to go to this other theory that wasn't pled, which is rescission. And there we see the parties not to be on equal footing, and therefore we're going to order some equitable relief here.
I take it, Mr. Sheketoff, and it's helpful only because of some of our other cases, that there's nothing in the record that I could see on a conceitedly cursory look at first blush that anybody was doing this in any kind of secret way, correct?
Correct. At least on this record, there's no evidence.
Do we have
that it was secret.
any evidence, for example, that, Bingham Dana, which is mentioned, didn't get a copy? I mean, do we know?
I do not know if on this record, I confess, I just do not know that there's anything in the record that shows whether or not Bingham Dana saw this contract or not prior to the litigation. I don't believe there is anything in the record one way or the other. And unless there are any other questions, I think I've made my position clear.
Thank you, Mr. Sheketoff.
May it please the Court.
Mr. Coleman?
Let me just deal with some of the questions that have come up so far. It was asked, for instance, whether or not the appeals court actually found this agreement to be illegal. Uncategorically, they did find it to be illegal. At page 6 of the opinion, they write, this is the appeals court, we conclude as a matter of law that the agreement violates GLC 3, Section 42, and contravenes public policy. Let me just read to you in terms of contingency. This dialogue at the depositions between counsel for NAGE, that's myself, and Mr. Arcidi and Mr. Lyons could have been written by David Mamet in terms of the statements on the part of both of them, their belief that this was, in fact, a contingent contract. Dr. Arcidi, this is in your appellate record at 168, page 91. I said I deliver, and I don't get paid unless I deliver. Question to him at appellate 169. Your understanding there was nothing further you needed to do after they had been designated and selected. True. You understand your role done once NAGE Fish selected as developer. Answer, that was my job. Your understanding what conditions had to be fulfilled. Number one, they had to be selected. Yes, there was nothing else. Lyons, I'll make sure you get $250,000, but I have to get the project or you don't get the money. Lyons at appellate 252. I gave him $200,000 once we got the go-ahead on the proposal. The record below, before the trial court and the appeals court, is absolutely uncategorical. Arcidi and Lyons.
Assuming that that's correct.
Yes.
Okay?
Yes, ma'am.
Just assuming that that's correct.
Yes, ma'am.
Why does your client get the benefit of having the money returned? That is the issue, at least one of the issues here.
Right. And there's two different theories, both of which are completely sound, I think, that answer your question. Number one, we pled, and you need to understand, by the way, we pled actually an aiding and abetting theory that we argued in front of the trial judge, and she granted summary judgment based on our papers. In our papers, at page 14, note 8, we also say, by the way, you can get to the same result through rescission, and we cite the leading case in this jurisdiction.
Did you raise that issue on appeal?
What I want to let the court know is,
did you raise that issue on appeal?
on appeal, we defended on the aiding and abetting theory. Yes, ma'am.
Did you raise the issue anywhere in a note, anywhere on appeal?
On appeal, the issue actually came up because the appeals court, I believe, probably seeing in our brief below that we had also raised this rescission.
I doubt that, but that's okay.
Well, in any event,
was the brief as part of the record appendix?
Yes, it was.
Then I take that back. They may well have seen it.
And here is the answer to. Let's go to the impero delicto, the theory that in fact the appeals court went with for a second. Justice Cordy, in the case of Wison versus Leon Enterprises, has before him, this court did in fact, a landlord-tenant issue in which the tenant had won below on the issue of constructive eviction. This court affirmed the judgment of the trial court below, but on a different theory. The court said the right result was reached, But the court, per Justice Cordy, wrote an opinion saying that, in fact, another theory, in terms of a theory that I would not be able to be as eloquent on as the justice was, on a theory of mutually dependent covenants. And my point to the court is this is not a waiver case. This is not an issue where we waived anything.
But we
This
can
is
affirm on an alternative ground where it was at least raised below.
That's right. And more importantly, this court, and that's what I'm getting at, this court has on more than one occasion said that when they have a record before it where the right result was reached by a trial judge, and they realize that, in fact, another theory was more appropriate.
Provided that there are no factual issues that come into that.
I agree with you completely on that.
Why isn't there an enormous leap of faith that says that, I take it he was then the president of NAGE.
Yes, ma'am.
This is on NAGE letterhead, it's drafted by the lawyer, that he was on some frolic and detour. I mean, the fact that a contract is unenforceable or indeed is illegal doesn't necessarily mean that, one or other party benefits entirely.
Right. I thought I heard my brother concede, and I think this is, in fact, the right analysis. It's an illegal contract, and we went through that. And if the court agrees with that, I think the next step follows. If the court doesn't, then I'm going to have to be in a different situation. Let's assume, as you asked me to, that it's an illegal contract. You know from memory of man runneth not to the contrary that the case law in this jurisdiction and every jurisdiction is that individuals are presumed to know the law. So when we went into this contract, forget what the record shows. The fact is that they're both presumed to know that it is illegal and, in fact, has been in this Commonwealth for hundreds of years before the statute, before the 1973 statute. They're both presumed to know that you cannot, on a contingent basis, say, I'm going to influence the decision maker, and if I'm successful, give me money. But they're both,
it's
they're
not
both
saying I'm
presumed.
going to influence the decision maker. It simply says, and I'm not getting back into the whether or not it was illegal.
Yes, ma'am.
Somebody else could be influencing. All he's saying, I'm getting paid, and as Justice Spina pointed out, the statute talks in contingent terms, but it doesn't mean that there's consideration for the fact that he did anything to influence the permit grantor. Okay?
What has been improper for hundreds of years before the 1973 statute is to, exactly as Justice Spina poised it, you cannot make a contract contingent upon the outcome because you're opening up a Pandora's box of potential mischief.
Whether or not it's an illegal contract. What I'm asking you to address is why does NAGE, which was an equal party, drafted the contract, got the benefit of, we don't even know what services were rendered.
Yes, ma'am.
There could have been all kinds of other services rendered. Why does NAGE get the benefit? It's not as if the Commonwealth gets the benefit.
There's two different theories. Number one, if you accept the fact that it's an illegal contract, both theories flow from that. Number one, if it's an illegal contract, then Lyons, as the president of NAGE, and Arcidi, by the way, the record shows, knew that, breached his duty as a fiduciary, and Arcidi, this is where we part company with the appeals court, Arcidi did everything that you can possibly do according to your case law in terms of aiding and abetting a fiduciary.
So why don't they get the money from the Lions? I mean, if these were two human beings that were involved, you couldn't recover the $200,000 fee, could you?
Right. Well, the record shows. What the record shows, I don't want to get outside the record. What the record shows is we have a pending lawsuit against Lions.
Well, that's different. But what I'm saying is,
so that's your remedy.
If your theory holds,
Yes, ma'am.
every time there's a corporate defendant, and some authorized person, i.e., the president, executes a contract, the corporate defendant, knowing full well, let's assume they both know, they presume to know the law, knowing full well that it's an illegal contract, is off the hook, and only the person on the other side has to pay them all that money back again. That doesn't make any sense at all, and that's not the case law.
Well, the case law is very clear on this, and that is that if in fact a third person assists a fiduciary in a breach, depriving therefore the beneficiary of the trust, and that's what in fact NAGE and the union dues payers are, the trust. If in fact a third party assists and aids and abets a fiduciary from breaching, the third party itself, and we've cited cases to that effect in our briefs, the third party itself is liable. And the point to you, Justice Spina, is there is a theory, of course, against Lyon. He breached the fiduciary.
Yeah, but if these were two corporations instead of a human being and a corporation, both corporate officials would be inducing the other side to breach their fiduciary responsibility. You could not recover, I take it, if Arcidi, in fact, were a representative of a corporation.
We would be able to recover from the corporation. In fact, there is a case, Augut, which is
Yeah, but
one of the-
Augut was different. Augut was very different.
But the defendant in the Augut case was, there's two companies, and the manager over here decides that he's going to jump ship and go over to company B, and he spirits away and pirates away.
Yeah, but
some of
he
the other-
wasn't acting on behalf of the corporation. Lyons was acting on behalf of the corporation, informed by the corporation's counsel, with a discussion of the executive committee. In Augut, the executive committee wasn't sitting around saying, we know you're going off.
You know, just to make sure that the record is understood here, this is me to Lyons. When you drafted the consulting agreement that we had seen earlier, did you do it on your own, or did anybody else participate in it? When I drafted the consulting agreement? Right. I don't recall who drafted it. I may have, but I doubt it. I think one of the attorneys did. So it's your recollection that one of the attorneys at NAGE drafted Exhibit Number 8? I'm not sure of that. I mean, don't be beguiled, in other words, by a record.
I'm not
This
being
is-
beguiled.
Well,
I'm
I
here
mean,
on a
no,
summary judgment.
There is
Summary judgment.
There is no record here that, in fact, Lyons had an attorney from
Is
NAGE.
there anything in the record, which I understand there is, but I may be, that the executive committee of NAGE participated in this decision?
And I'm so glad that you asked me that, because I've got pages that answer that question. And this is in your appellate record at 255. So it's your testimony that you had individual discussions with members of the executive board, yes, but not all.
I'm sorry, who's the deponent?
This is Mr. Lyons testifying, not the entire executive board. Did all the executive board members, according to you, approve that expenditure? No, they didn't have to. And this decision that is being made by you, well, it was made by me. I discussed it with some of the members of the board, but under the Constitution of the bylaws, I had the right to do this. Besides the lunch you just described, was there any other persons by which it was approved? No, I had authority.
And this was known to Mr. Arcidi?
This was not known. I just want to stay in the four corners of whether or not NAGE qua NAGE, through its executive board.
But again, from Arcidi's point of view, the question is why, I mean, I'm simply repeating the question that Justice Spina asked.
Right. And the answer was already given to by my brother counsel, which he conceded, if this is an illegal contract, and that was the hypothetical or the assumption you asked me to assume, if this is an illegal contract, everything else flowed. It was a fiduciary breach. There's no question that Arcidi aided and abetted.
Do you have any case other than Augut?
In terms of, on the issue of, yes, I do.
I mean, you can rely on your brief as well, Mr. Coleman.
May I ask a question?
Yes, sir.
Would you agree that if the NAGE executive board had voted to approve of what they understood was an illegal contract, that they then Arcidi should not be required to refund that $200,000?
Here's where I think that resonates a little bit. The Court of Appeals, and I think the Appeals Court quite properly, came to the conclusion based on this record, and it doesn't show anything else, that the executive board did not approve this contract. And I think that according to the Appeals Court, I'm not trying to psychoanalyze here, but the way the Appeals Court writes its opinion, it seems like that had influence on the Appeals Court. What the Appeals Court was saying, in other words, is...
But no, I don't want to...
And this is in the impera delicto area. In other words, I think one of the reasons why the court below found an uneven amount of blame here is because on the one hand you have Arcidi over here, and on the other hand you have Lyons, but with no executive board approval. And I think it resonates there.
I don't want to split hairs.
Yes, sir.
There was apparently executive board knowledge, at least knowledge by some members of the board.
That's the most you can say. At a lunch, he identified some executive board members who he said, and this is for the sake of the record we have here, but
Mr. Coleman, let me ask you
yes,
this
ma'am.
question. I'm looking at this, because there's no evidence in this record that Lyons acted with authorization from NAGE. I found that statement of the appeals court interesting for this reason. There was testimony, which you have just read, and I haven't read that,
Yes, ma'am.
the deposition in full, that Lyons was authorized by the Constitution and bylaws, which I don't believe has been challenged by NAGE, that he had the authority to enter into a contract of this kind, leaving aside whether or not it was illegal. Now, generally speaking, if you're looking into the validity of a contract, let's say there was not an illegal contract, this was a legal contract, it only talked about building, it wasn't contingent on approval, and NAGE said, you know, we're not going to pay. Arcidi sues, and it turns out that Mr. Lyons is authorized by the Constitution and bylaws to execute a contract on behalf of the corporation. Generally speaking, that's the end of the case. So I literally don't understand when the appeals court said there's no evidence that Lyons acted with authorization.
I think, and again, as Justice Ireland said, I don't want to split hairs. It's an illegal contract, and, you know, God himself could have ratified the contract. It's an illegal contract, period.
I'm not
I think what the appeals court was saying is we find that it violates public policy, and you all have plenty of cases on that as well as a theory for allowing somebody in NAGE's shoes, by the way, to recover. It violates public policy, and we find a little bit of disparity. Lyons, by the record, did not have executive board approval. It wouldn't change whether it's an illegal contract. It's an illegal contract until the cows come home. But in terms of the paradelicto theory, I think the appeals court thought that the absence of executive board approval, that put the balance a little bit to the point where...
And that's the only theory under which you can recover under the appeals court analysis.
Under the appeals court
rescission
analysis.
and restitution analysis
Right.
is if you stand in substantially different shoes.
Exactly right. And this is
Less culpable.
This is a doctrine that again goes back. You know, literally, we have cases literally hundreds of.
But this contract was entered for the benefit of NAGE.
Right.
It wasn't entered for the benefit of Mr. Lyons.
Right.
NAGE was the one who had invested in getting this development approved.
Right, and it's NAGE money as well. That's right. Right, and I guess I'm not sure whether you and I are meeting in the place that I'd like to be meeting at, but what I take.
I don't think we are either. But
what I take from that is when the fiduciary enters into what has to be considered to be an illegal contract, does not get executive board approval, that even in the scope of rescission, it makes sense. There's no question, forget rescission for a second, there's no question that under our theory of aiding and abetting, and I'm going to give Chief Justice Marshall some more cases, there's no question that under the theory of aiding and abetting, if you find A breach, which there is, it's an illegal contract, and B, Arcidi substantially assisted that breach, he did, no question about it, there are cases, legion of cases, that say that the person who assists the breach is itself, himself, or even if it's a corporation, itself liable. And Justice Sossman, I think you were trying to get my attention.
that's under the aiding and abetting theory.
Yes, sir.
Yeah. No, never mind, it was on the peridelictal theory, and
Let me just-
time's way up, and
Mr. Coleman, your
So-
time is up.
If I could, just a couple...
No, your time is up,
Yes,
Mr.
ma'am. Fine.
Coleman.
Thank you.
Thank you very much. Thank you.